is the debtor's motion to compel the TCC to supplement certain interrogatory responses and document requests.
Yes, sure, Your Honor. My partner, Dave Torborg, is going to handle that.
Oh, okay. Mr. Torborg? Was he given presenter status?
Can you hear me now?
Yes.
Oh, sorry about that. I think I got muted. Good morning.
Good morning.
Thanks for taking the time to hear this. You certainly seem like you feel better, at least.
We're getting there, yes.
So our motion to compel the TCC seeks two things. One, any estimate that the TCC has concerning the debtor's top liability. And two, the foundational basis for its contention that LTL's board members breached their fiduciary duties to creditors. On the first issue, there is and can be no dispute that the extent of the debtor's top liability is relevant to the issue of financial distress. On the one hand, the TCC contends that LTL is not in financial distress. On the other hand, they say that the $8.9 billion proposed settlement is woefully inadequate. The latter suggests, of course, that they believe the liability is more than $8.9 billion, perhaps significantly greater than that. Given that, we've asked the TCC to identify any estimate it has of the debtor's talc liability. In response, the TCC has stated it has no non-privileged documents. Now, if the TCC intends to put forth expert testimony on that matter, then we'll see it next week in expert reports. No problem. But it's not clear to us that they are intending to do that. None of the experts that they've disclosed to date have been identified to testify on that topic, and none of them appear to have any prior experience on that matter. What the TCC cannot do is simply refuse to state whether it even has estimates of the debtor's liability for talc claims. Local Bankruptcy Rule 7026-1 is very clear. It states, when a party asserts a claim of privilege in response to or objection to a discovery request, the party must identify the nature of the privilege claimed and indicate whether, with respect to the privilege, any document exists or any oral communications occurred. Notwithstanding this clear language, the TCC has refused to simply state whether it has any such estimates. Now, why does the debtor care? Well, we want it to be perfectly clear in the motion to dismiss record whether the TCC has estimates of the debtor's talc liability, but has declined for whatever reason not to provide those estimates to the court in connection with the motion to dismiss. It's entirely predictable that the TCC, given its role, does have such an estimate and would intend to use that in connection with plan and confirmation proceedings, and arguing that the debtor's proposal is inadequate. Let's say hypothetically the TCC believes that the debtor's talc liability is in the nature of, say, $25 billion. To be clear, I'm making that figure up. No one's told me that. That's hypothetical. Well, if that's the case, that would clearly be relevant evidence to whether the debtor is in financial distress. It would be unfair for the TCC to decline to reveal that estimate now at this stage of the case, only to then trot out such an estimate later in connection with plan confirmation. It should either reveal the estimates now or be a stop from relying upon them later. At the very least, the TCC should be compelled to tell the debtor and this court whether they have an estimate or estimates of the debtor's talc liability, regardless of whether they will use them at the hearing. That will allow this court and the Third Circuit to make any inferences that are appropriate. I have a few points in response to their points, but I'll keep that for rebuttal. That's the first issue. The second issue is our request in interrogatory number 10 that the TCC provide the foundational basis for its contention that the amendments to the financing arrangements between LTL, Holdco, and J&J breached the LTL members' fiduciary duties to creditors. The TCC's response to date has simply been to refer to the attempted stripping of the 2021 funding agreement and then pointing us to go look at their motion for derivative standing. But corporations engage in transactions all the time that serve to change the relative balance of their assets and liabilities. Such transactions may give rise to potential breaches of fiduciary duties only if the corporation is rendered insolvent. In the All-Serve decision, this court extensively discussed New Jersey law on this topic. That included the Francis versus United Jersey Bank case, 87 NJ 15, 1981. That decision stated, while directors may owe a fiduciary duty to creditors also, that obligation generally has not been recognized in absence of insolvency. Neither of the TCC's excuses for providing an appropriate response have any merit. First, they say that this fiduciary duty contention was made in a single line in a brief. Well, it was actually 2 lines, and in any event, it made the statement. We're entitled to know the basis for it. It's a relevant issue in the case. And second, they claim that we're asking for their legal analysis of the breach of fiduciary duty claim. We're not asking for that. We're asking for the factual basis, including whether they contend the LTL was rendered insolvent as a result of the funding agreement changes. Solvency is a factual question, not a legal analysis. In a 2011 decision in the W.R. Grace bankruptcy, 446 PR 96 at 105, the Delaware Bankruptcy Court stated, we agree that a determination of solvency is a question of fact. So the TCC cannot refuse to answer on the basis that we're asking for a legal analysis. Unless the court has any questions, I'll cede the floor to the TCC. Thank you.
Thank you. I might have questions, but I'd rather hear from the counsel for the TCC first. Who will be Mr. Winograd?
Yes, Your Honor. This is Michael Winograd from Brown Rudnick, proposed counsel for the TCC. Your Honor, let me just say a couple of quick things. Counsel for the debtor suggested that he would hold his reaction to our points that were in a brief for rebuttal. This is the kind of gamesmanship that I'm going to talk about in a moment. If he wanted to address, this is like the standard case law on expert opinions. If you know it's an issue, you know all the facts, it should be in an opening, not in a rebuttal. If he had something to rebut in our briefs, he should do it on his opening, not sort of save it for the last word. Be that as it may, Your Honor, I'll address each of these in turn. First of all, the amount, let me just say something at the outset, Your Honor. The number of impasses that we have reached in this case on mundane discovery issues has to be unprecedented. Your Honor said it seems like there's something every day on this case. We are concerned about the delays and the timing of these motions, and I'll get to each of them in a moment. With respect to this first motion, the existence, let me just address the timing. This is directed to 2 TCC responses. The motion to compel was filed on May 25th. The responses and objections were received 10 days earlier on May 15th. They waited 10 days after that, including having received productions on the 18th, but they waited 10 days to file this motion to dismiss. And again, we'll talk about it with respect to the second motion where it's even more egregious, but it's really becoming prejudicial. With respect to the first issue, Your Honor, existence of the liability of talc estimates, we responded that there are no non-privileged analyses that we have. That's not to say that we do or don't have anything that's privileged. We don't have anything that could be subject to discovery. That shouldn't be a surprise. They're asking us effectively if we have some sort of, I guess, damages estimates. It's privileged information. We've clearly responded, we have nothing non-privileged. What I think they want when counsel says, well, you have to tell us if something exists, I think they're just asking for a privilege log. And we have raised this time and time again with them in meet and confers. The parties have simply not exchanged privilege logs. And to give you an example, as we cited in our brief, we asked counsel for Mr. Murdica, who's counsel for J&J, resolution counsel for J&J, in his deposition, did you calculate a per case average? Not what it was, did you do it? We were told, he was instructed not to answer based on privilege. We asked him, did you compare two claimant lists? He was told, do not answer based on privilege. We never got an answer. We never got a privilege. Those are indistinguishable from the case, the issue at point. The parties simply haven't been exchanging privilege logs, and that, as far as I can hear, is all they're really asking for. And let me just make one other point before I move to the next topic, Your Honor. It seems like, in some respects, this motion is a veiled effort to file some sort of motion in limine to restrict arguments that can be made at a motion to dismiss. If that is, in fact, the relief that debtor wants, they should file a motion in limine. Similar to if there is no difference if they're complaining that information that is privileged shouldn't be able to be used as a sword and shield, just like they wouldn't produce any of the alleged common interest materials concerning the termination of the 2021 funding agreement. If they want to make a motion in limine, they should make it, but they shouldn't do it sort of subtly, underhandedly through this motion to compel. Let me move, and unless Your Honor has questions on that topic, I'll move to the next one.
I'm going to hold all questions. Go ahead.
Smart, Your Honor. Your Honor, the next is, whether it was one line or two lines, it was not even a full sentence. It was set off by M dashes in a sentence. It was a part of a sentence in our PI objection that said, the attempted stripping of LTL's most significant asset in clear breach of LTL's fiduciary duties. That's what it's at issue. The debtor says they just want the underlying facts, as though this is sort of a contention interrogatory. We all know what the underlying facts are. There was a transfer of a consumer business that represented 50% of Holdco's value. Then there was a termination of the 2021 agreement. And then there was a substitution of that agreement with a new 2023 funding agreement that had Holdco, who had just transferred half of its assets, as the sole obligor, and J&J's backstop was gone. We cited to those very explanations, which were fairly detailed in our objection to the PI and in our standing motion. The only thing that could possibly be left is an analysis of how those facts constitute a breach of duty. That is an analysis. That is a legal analysis. It is clearly work product. It's protected by Rule 26 and by Rule 33, which only permits discoverable information under 26. We cited the Upjohn case. This is crystal clear and squarely within the privilege. Now, LTL, I know that counsel just cited a whole bunch of cases that were not in its brief, and I have not read them. I can't address them. Started talking about solvency, which they don't mention. But what I can tell you, Your Honor, is they cite one case. And the one case that they cite, that somehow an attorney's legal analysis as to whether something constitutes a breach of duty that was stated in a legal brief, in the past, by the way, it's not even a brief in this motion, is somehow subject to discovery. They cite one case, and that was the Barnes case from the District of DC in 2010. And that case undermines their position, as we noted in our brief. The court there, in discussing and describing the interrogatory at issue, said plaintiff's request essentially asks for defendant's contention as to the accuracy of the detention and strip search data spreadsheet. This is a contention that relates to a fact. The court granted the motion because it was a request to verify the accuracy of data in a spreadsheet. That is not the same as a request for a lawyer's legal analysis that supports its legal position that's set forth in a prior legal brief. Your Honor, this motion should be denied for multiple reasons that I just outlined, Your Honor, out of hand. Thank you.
Right. Thank you, Mr. Winograd. Sometimes I wonder what it would have been like had I just acceded to your request and had all the arguments done on May 23rd. What would you all done for the past month? Mr. Thorborg, respond.
Yes, I would like to address a couple of points. Thank you, Your Honor. First, in terms of the timing of when we filed the motion to compel, we had a meet and confer between the time we got the responses. There's no deadline for us to file any such motion. We're working as hard as we can. I think the court appreciates we have a lot on our plates. We filed the motion well over a month in advance of the hearing on this case, so I don't see the reason for that complaint. On the first issue, on the estimates, I didn't hear any response to Bankruptcy Rule 7026-1, which I think is dispositive. We're not looking for a privilege log. We're looking for an answer to an interrogatory and production of documents. And then finally, with respect to the discussion of in their brief about instances where our counsel has appropriately instructed witnesses not to answer, that has nothing to do with this interrogatory. It's completely irrelevant. The fact that they're going to those lengths to respond suggests they won't have much to say in response to the issue here. On the question of the breach of fiduciary duty interrogatory, if Your Honor has read our brief, we clearly did cite case law and discuss the issue of insolvency, including Your Honor's opinion in Ulcer. But I don't know if Mr. Wintergrass been too busy to read the brief, but we clearly discussed that. And then secondly, I didn't hear any response to our points that we would like to know if they're alleging that LTL was rendered insolvent, and if so, how. That's clearly a factual issue, and we're entitled to a response on that. So that's all I have. Thank you.
All right. Thank you. Mr. Winograd?
May I respond, Your Honor?
Yes.
Your Honor, as to the timing, we're talking about 10 days. It's even more egregious in the next motion, which we'll talk about. In terms of this being a month in advance of trial, we have depositions going on. It was dropped. And in fact, on their own request, even though it was fully briefed, they delayed the hearing till today. It's smack dab in the middle of depositions, which we, the TCC and other counsel, are taking. The idea that the exact same instructions not to answer that have never been, no answers to which have been provided, is somehow irrelevant. They are indistinguishable. They are literally indistinguishable, as we set out in the brief. And the idea that we should be instructed to answer on insolvency, that's simply not what they asked for. They said, provide the basis for the contention that LTL board breached fiduciary duties. That's just simply not at issue here. I would have, a separate response for it, Your Honor, but it's simply not what is at issue here. They are asking for, we have explained to them the factual basis underlying that statement of law. They are simply asking for legal analysis. Thank you, Your Honor.
All right. Thank you all. With respect to the request for estimates as to the dollar value of the aggregate liability, or estimates as to the amount that would be required to resolve the liabilities in the court system, the court at this juncture can't imagine that information wouldn't be subject to work product or attorney-client privilege. That being said, there is a requirement under both local rules and under the federal rules to identify whether the committee is required to identify whether it has that information or documents. I'm not requiring a privilege log, given the restricted and constricted schedule that we have. But the committee should basically give the converse of the answer it already gave. It acknowledged it had no non-privileged documents or information. It should acknowledge that it has information or documents, that they are subject to appropriate privilege. What that does for the debtor is beyond me, but I'm not here to strategize. But I'm not going at this juncture to require any type of privilege log be completed. It couldn't possibly be compiled or reviewed in advance of the motion to dismiss. So I remind everyone that under Rule 26B1, proportionality, the need and the needs of things, which include the needs of the case, the relevance of the issues, and the relevance of the discovery, all are taken into account. So there should be what I'm requiring is simple responses identifying whether or not the committee is in possession of information or documents for which they assert a privilege that would be responsive to the discovery sought. With respect to the contention interrogatory, the committee is required simply to advise the debtor whether or not it is in possession of facts beyond which they have included in their standing motion or PI response. In other words, are there any additional facts which support the claim that LTL's management engaged in a breach of fiduciary duty that are not included in the information provided to date or referenced in the responses? Needless to say, when we get to the hearing on these matters, we're going to look at what's been provided and what has not been provided in discovery as to whether evidence at trial would be admissible, or we'll consider it on motions in limine in advance. If I don't believe there are other issues with respect to the motion under docket 604. If not, we can move to debtor's omnibus motion to compel plaintiffs' firms to supplement their responses to interrogatories and document requests. I think it's docketed at 638. Mr. Torborg, are you up again?
I am up again, Your Honor.
All right.
Thank you again, David Torborg, Jones Day on behalf of the debtor. This is a motion directed at 9 plaintiff law firms. These law firms either represent individual members of the TCC, have filed motions to dismiss on behalf of one or more clients, or have otherwise been active in these proceedings. I'd like to start with a little bit of history because I suspect this might be a little confusing. Initially, we served Rule 33 interrogatories and Rule 34 requests for production. Those discovery requests were directed to certain plaintiff firms and their individual clients. So, for example, the debtor's interrogatories to the Arnold & Idkin firm were directed to Arnold & Idkin LLP and Arnold & Idkin LLP acting for Arnold & Idkin talc claimants. Some of the plaintiff firms to which we served this discovery objected that the discovery was improperly served on them, claiming they were not parties to the motion to dismiss proceeding. Nonetheless, many of the firms did respond to the discovery, albeit largely with relevancy and privilege objections. Given the objections to whether they were appropriate parties, the debtor thereafter, 2 days later, served Rule 45 document subpoenas on these plaintiff firms and 3 others. The debtor's motion seeks 3 categories of information. First, we seek information on the total number of talc claims against the debtor, filed and unfiled, for which the law firm served as counsel. There should be no debate that the number of talc claims faced by the debtor is relevant to the issue of financial distress. Most of the firms responded simply that the debtor already has information on the number of claims filed against it. That, of course, tells us nothing about the number of unfiled claims. There is no good reason to withhold the requested information. It should not be hard to provide. Beasley Allen and Muni Reichel identified the number of unfiled claims for which they serve as counsel in response to the interrogatory. One firm, the Barnes Law Group, argued that it cannot identify how many unfiled claims it has because those claims have not been fully investigated and evaluated. The TCC, which weighed in on this motion despite discovery not being directed to it, makes the same point. But we didn't ask how many claims will definitively be filed. We asked the number of claims for which the law firm serves as counsel. The fact that the claimant has sought counsel concerning the possibility of asserting a claim is relevant to the debtor's top liability. The TCC seems to argue that the number of claims or potential claims from just 9 plaintiff firms is not relevant because there are more than 100 firms that have such claims. That may be so, but these firms have taken a leadership role in this case, and the information sought is relevant. The TCC further argues that the court earlier this week declined to order the discovery sought here. The court did no such thing. It certainly has not held that the number of unfiled claims is irrelevant to the question of financial distress in the motion to dismiss proceeding. Before I move to the next issue, I would like to address again the suggestion that the debtor should have filed this motion weeks ago, according to the TCC. Well, the discovery was not even served until 3 weeks ago. At the time we filed the motion, the responses that came in were less than 2 weeks old. And unlike the TCC's practice, we actually endeavored to follow the local rules, meet and confer, send letters outlining our problems with it, and propose compromises. There's no deadline to file the motion. And again, we filed this motion more than a month before the hearing. So that's the first issue. The second issue is the debtor's request for communications between the 9 plaintiff law firms on one hand and any other law firms or claimants on the other, relating to the $8.9 billion proposed settlement. Some 7 of the law firms refused to identify or produce any responsive communications, generally asserting privilege objections and stating they have, again, no non-privileged documents. Communications about the proposed settlement are plainly relevant. Among other things, the communications may lead to the discovery of relevant evidence concerning the level of support for the proposed deal, efforts and motives of law firms to undermine it, and whether the proposed settlement is viewed as adequate. There is no serious challenge to relevance. We recognize that there may be some responsive communications that are privileged and subject to common interest protection, such as communications between firms that represent members of the TCC. But as this court well knows, not every plaintiff firm holding TAL claims against the debtor is aligned when it comes to this bankruptcy and the proposed settlement. There is no indication that the firms took this request seriously and actually searched their files for responsive communications and assessed the appropriate scope of any permissible common interest protection. The law firm should be required to do so. The final issue concerns any documents in the law firm's possession that bear the debtor's financial distress. That's request for reduction number 15. The debtor is entitled to whatever documents the firms have or intend to use at the hearing pertinent to that indisputably relevant issue. Non-responses or generic responses to briefs or press releases are not sufficient. If the firms have nothing to produce, that's fine. But if they do have information on that issue, such as estimates of the debtor's top liability, it should be produced. Finally, I would like to respond to the brief that the Rutt-Shell firm filed. It accuses the debtor and Jones Day of bad faith, sloppiness, carelessness, and the like, on the basis that that firm never invoked a claim of privilege. Our deficiency letter did inadvertently transpose another firm's objections to that firm's objections. But the Rutt-Shell firm did, in fact, assert a privilege objection in its objection. While the responses did not use the word privilege, the first page of their objection states, service of discovery upon counsel for a claimant seeking the thought processes and personal opinions of counsel regarding a proceeding is improper, absent some showing of how such discovery relates to an issue in this case and would lead to admissible evidence. They made a similar objection 2 pages later. We interpreted this as a general privilege objection, and we believe Rule 7026-1 also refers to assertions of work product protection as a basis for needing to follow the local rule. So unless the court has any questions, that's all I have. Thank you.
All right. Again, let me hear, and I expect I'll be hearing a little bit more this time from more firms. Mr. Ruckdeschel?
Thank you, Your Honor. I had to get the mute. Now let me take my hand down. I'm glad you're feeling better, Judge. I appreciate the time. The first waffly explanation we've heard about the fictional demand letter sent to me by Jones Day happened right now. They sent a demand letter on May 22nd about the responses that I filed on behalf of my firm. I did maintain then, and I maintain now. It is improper to serve discovery on counsel, asking about counsel's opinions about things that are outside of their representation of a particular client. To the extent that the debtor wanted to seek information from Mr. Crouch about positions Mr. Crouch was going to take, that discovery needed to be served on Mr. Crouch, and he would have responded. And he would have asserted whatever appropriate work product privileges, work product or attorney-client privilege that was applicable. That didn't happen. The discovery was served on me. And let's be clear, while there was a stray comment in the interrogatories that were served, that they were serving it on the firms and on the individuals represented by the firms, the motion to compel acknowledges that the debtor has no complaint about what my firm did with respect to the interrogatories. They only raised one issue: tell us how many unfiled claims you have. And while I don't believe that's appropriate, I don't believe it's discoverable, I don't think it's important, I didn't want to bother the court with it. And so, as I said in my opposition to the motion to compel, I nevertheless told them, while I stand on my objections, I don't want any unnecessary bickering, and I don't have any clients that have told me they want to file a claim against the debtor that have not yet filed it. And they acknowledge in page 3, footnote 3 of the motion that that was sufficient. So there isn't any issue to compel my firm with about the interrogatories. And then we go to the document requests, which are only served on my firm. And again, the materials that my firm has related to my representation of Mr. Crouch are the property of Mr. Crouch. You want to do discovery of them? You serve the discovery on Mr. Crouch. He has his rights. He'll raise them. That didn't happen. Right? They served a subpoena on my firm. And when I responded to that, they filed a two-page letter that goes into great detail, including an alleged quotation from the responses that's just fictional. It doesn't appear. That says, I asserted a claim of attorney-client privilege. They quote something that doesn't appear in my responses. They go into their explanation about the local rule and about discoverability. It's fiction. Didn't happen. They didn't come back when I pointed this out to them in my letter hours later. It took just hours for me to respond. I responded on the same day. And I said, hey, I didn't raise that objection, so I don't have any idea what you're talking about, and I'd like you to withdraw it formally because you've now quoted things that are just fictional. Doesn't appear. What do I get in response? Nothing. Nothing. What does the motion to compel say about this little fiasco? Nothing. The first time we hear anything about it is counsel's attempt this morning to say, well, we interpreted this language in 2 sentences in your responses as an assertion of privilege. Well, I didn't hear that when I sent them the letter. and the letter's pretty strongly worded. I quoted from it in the motion, in the opposition. I attached it for your honor. And it's very clear that I was taking the position that I hadn't raised a claim of privilege, period. And nevertheless, no response. So what's the next thing I get? May 25th. Well, as a compromise, we'd like you to do this other stuff. They'd never raised these other alleged deficiencies with me. They raised one objection to the request for production. You asserted privilege and you didn't give us a log. Well, I didn't assert privilege, and it's true I didn't give them a log because I didn't assert privilege. And it's improper to serve discovery on me for my personal stuff. And I got to tell you, Judge, if you're seeking discovery of my John Ruckteschel or the Ruckteschel Law Firm's personal opinions about things beyond the positions I might take for my client, it's not going to be helpful to anybody. And we're going to have to figure out some ways to be clear that we're not overly colorful, because I'm a colorful guy when I talk. And when I'm expressing my personal opinion, I do it. And that's not relevant to this case. The positions that I take on behalf of my client, for my client, before this court are relevant. And those are his. My personal information, what I personally think about the propriety of this proceeding, about opposing counsel, about settlement offers that haven't been made, or this alleged plan that's been submitted. My personal opinions aren't relevant. They're never going to be admissible evidence in this case. But that's the problem. There hasn't been a meet and confer about this because there was nothing to meet and confer about. They raised one set of objections in May 22nd to the request for production. And that objection was, you asserted privilege and you didn't give us a log. Well, I responded to them. I didn't assert privilege. Done. I dealt with their only objection that they raised. 3 days later, now they've got something else they want to do as a compromise. Well, what do I have to compromise about? I did what they asked. I addressed the concerns that they had. Is this just going to be an ever-shifting, well, we're going to ignore what you said. We're going to ignore that we messed up and we had a fictional letter we sent you, and we're not going to acknowledge it, but now we're going to demand that you do other stuff. It's inappropriate. Nothing I have is discoverable other than what I might do on behalf of Mr. Crouch, and they didn't serve discovery on Mr. Crouch for documents. The motion should be denied. And, Your Honor, the more you let this gamesmanship go on, the more they're going to do it. Every time. You know, we've just heard in response to the TCC's motion, we've just heard in the preface here, well, there's no deadline, and we served it a month ahead, so apparently there's no hurry. Well, if there's no hurry, why do we have a request, an ex parte request to shorten time? If we've got another month, why did I have to rush back from taking my wife to the doctor so I can do this hearing here in my kitchen? Because they think we have to shorten time, and then they come before you and they say to the court, well, Judge, we've got a whole nother month until the hearing. Those two things can't be true, and you got to put an end to it, Judge. You got to stop this. Thank you. The motion should be denied.
All right, thank you. I have a question, Mr. Ruckteschel. I'm going to ask it of you, but I'm going to hear the answers from counsel for the other firms that have been for whom discovery is sought.
Of course.
If there's an interrogatory or if there was a subpoena served on the firm with the intent of drawing out information relevant to financial distress, and the subpoena sought information as to the number of clients who have retained the firm to pursue claims for injuries due to use or exposure to talcum powder sold or marketed or distributed by J&J or its affiliates, for which a lawsuit has not been filed. Why is that not relevant? And why would it be privileged? It's asking for a number. It's not asking for any communication.
Well, I can answer on behalf of myself, Judge. Right?
That's all I'm asking for at this point.
And it's easy for me because the Ruchter Law Firm is me, and now my wife has reactivated her license and she's working about half time with me. God help her. But I only have a handful of cases. But what I can tell you is when clients come to my firm and they retain my firm, the first thing we have to do is investigate. And we investigate what their potential claims are, both in the tort system and otherwise. We then investigate what we believe the relative likelihood of success might be, right? We have to go through all this process with these things, and then we have to make a recommendation to our client as to what we believe the best course of action is for them. And then, and only then, do they then decide what course of action is it that we're going to take. And I can tell you that there are often months in between the time that a client comes into my firm and retains my firm and the time that we actually make a decision about what we're going to do, because the investigation takes a long time. And that's particularly true in the case of people, women that come in because their exposures are often secondhand, and so it takes more time. And it's often true in the case of people that have more complicated work histories and exposure histories. And it's often true in people where we've got to look. And so the fact that you've retained a law firm doesn't mean a lawsuit's going to be filed. It doesn't even mean a lawsuit's going to likely be filed.
But doesn't that go to the inferences the court could draw from that evidence, or the weight given to the evidence, not as to discovery?
Absolutely not. Absolutely not. And there are two reasons why. One, it's completely irrelevant under the analysis of the Third Circuit in LTL 1, which says the question here is there an immediate financial distress? And so speculating about things that might happen in the future is not part of what this court's proper analysis should be. So for the purposes of the motion to dismiss, that's not the analysis that Your Honor should be doing. And the facts that could be hypothesized of, well, if this happens and that happens and this happens, then there'd be another claim filed. And then if that claim gets filed and if that happens, this happens and that happens and this happens, that's exactly the kind of inferential chain that the Third Circuit said, that's not on the table. That's not what we do here. So that's number one. It's not relevant and it's not reasonably calculated to lead to the discovery of admissible evidence. But number two is what I went through a minute ago. The fact that somebody hires my firm doesn't mean that I have an expectation that I'm going to sue any particular defendant. And there could be an exception to that, right? A lifelong guy comes in from Pennsylvania and he was hired, worked for U.S. Steel his entire career. And in Pennsylvania, you can sue the employer. Right. I'm pretty sure when that guy hires me, I'm going to sue U.S. Steel. But that doesn't happen. That's a rare case indeed. And so the problem is the fact of retention means nothing with respect to whether a claim is going to be filed. It means nothing as to whether it's more likely than not that a claim will be filed. It means nothing. It's just a piece of nonsensical data that means nothing. In order for it to mean something in this case, you have to take at least three more inferential steps. And so that's just inherently speculative. If somebody has, and this is the response I gave to them, none of my clients have advised me that I should file a claim against the debtor. Right? That's what I responded, and they accepted that. So that's fine. Okay?
All right.
So that's my answer, Judge.
All right, thank you. Let me move to Mr. Satterley.
Good morning, Your Honor. I guess good afternoon there in the East Coast. And I'm sorry to hear that you've been under the weather, and I hope you get well soon.
Thank you.
Let me echo some of what Mr. Ruchter has said, and I'm not going to be as long as he is. He made very good points. But I want to start with burdening Your Honor. This is unduly burdensome that the debtor has brought this to your, put this burden upon you, because it's basically harassment. And they brought this to you claiming they've met and conferred when they haven't. I served responses on May the 15th of responses and objections on behalf of my law firm. And I produced a document. I'll talk about the document in a minute. But I haven't heard a single phone call, I've been in court in the Valadez case every day for weeks. We've done opening statements, we're putting on evidence, and against many J&J and LTL attorneys. There's I don't know, 5, 6, 7 there. And at no point in time did anybody say, hey, by the way, Joe, you didn't adequately answer discovery. Nobody picked up the phone and called me and said, you need to produce some other document. So I don't even know what letter. I suppose somebody from Jones Day wrote a letter to me. I haven't seen it. I've been sort of busy lately. But so I guess my point is there's really not been any meet and confer on this issue. And so for this emergency motion with advancing to today, I think is just an attempt to harass us and to burn the court. So let me directly address the 3 points, the 3 items that counsel says my firm should answer. The total number of claims, the first item, the total number of claims of filed versus unfiled. In the response to the discovery, I provided a letter dated April the 20th, 2023, to Ms. Allison Brown and Alex Calfeld. I said, in light of Judge Kaplan's ruling today, at today's hearing, because Your Honor told us on April the 20th, if you intend to file a lawsuit, let them know. In light of Judge Kaplan's ruling at today's hearing, I write as a courtesy to inform you that the case and firm's clients will file lawsuits against Johnson & Johnson and other protected entities, but not against LTL Management. Each complaint and summons will be served through official channels. The cases that will proceed immediately include at least the following. And I listed all the cases that we intend to file. Any other case beyond that is work product privileged. Because as Mr. Ruckteschall said, we're investigating the merits of the case. And there's many cases that we investigate and decide not to take, not to accept. My firm has a history, and Johnson & Johnson knows this, that we represent some of the strongest cases that you could possibly imagine. You know, they have autopsies or tissue digestions, and the exact ingredients are found in the body right next to the tumor. We're very, very particular about the type of cases that we select to represent. So any client that is not on this list is work product privileged. And I would reassert what Mr. Ruckteschall said about if an attorney or if a client has retained us, that doesn't mean we're actually going to file a lawsuit. We're still they're retained to investigate. So the total number of unfiled claims is privileged, and to the extent that Your Honor compels that type of privileged information, I'll have to seek appellate relief, because there's under no circumstances am I turning over privileged information. The second item that they sought is communications that I may have had with other lawyers regarding this topic. And I asserted privilege as well. Co-counsel privilege. I'm co-counsel with Mr. Myman. Moshe and I have represented cases against J&J for years. Any communication I have with my co-counsel is privileged, and I'm not going to turn that over. The final issue is financial. My opinion about financial distress, my views about financial distress are not relevant. And my opinion about the value of each of my cases is privileged. Now, I did point out in the discovery that I have, they've already have the demand letters that I've made on individual cases. They already have what's called a 998 filing. A 998 in California is a actual pleading type documents that's served upon the defendants, so that when we win the case, if they don't meet that, we can get costs. And they already have those. So everything that I have that's not privileged has been turned over, and everything they're seeking is either harassment or they're seeking privilege. Final point, Your Honor, the focus at the motion to dismiss is not on Joe Satterley or the Kazin law firm's thought processes about the debtor, or Joe Satterley or Kazin law firm's evaluation of each individual case, because I evaluate cases and I have thought process. That's not the focus. The focus is on the debtor. And the debtor has repeatedly said in deposition that they did no analysis, no estimates of their liability. So that's got to be the focus on the motion to dismiss, not on Joe Satterley's thought processes. And with that, I'll submit, Your Honor. I hope Your Honor gets feeling better.
Thank you, Mr. Satterley. Mr. Winograd.
Thank you, Your Honor. Mike Winograd from Brown Rudnick, again, on behalf of the TCC. And Your Honor, I will try not to tread ground that's already been covered. And of course, I'm speaking on behalf of the TCC and not the member representatives that received these subpoenas. First of all, Your Honor, the flippant comments by counsel that somehow the TCC doesn't follow a practice of meeting and conferring is outlandish. I won't say any more than that other than to say in the 20 or 30 issues that have come up, we have affirmatively reached out to them on almost every single one of them. They've cited one instance in the last briefing, and again, we reached out to them to discuss that issue, apparently not in some formal meet and confer setting. We were never consulted on this motion before it was filed. I understand we're not a subject of it, but we're certainly related, and when I've reached out, it's been to the entire group on the other side. With respect to the gamesmanship, Your Honor, this motion, and I expressly request that this motion be denied simply based on the timing. The responses and objections at issue were received on May 17th or earlier. It took them 2 weeks to file a motion, which they filed at 11:20 at night, and then suddenly asked for a hearing 2 days later. Now, I know counsel says there's no rush here. Well, if there wasn't a rush, as Mr. Ruckshell said, well, why the 2 days notice? But in any event, they sat on their hands for 2 weeks. That alone warrants denial, Your Honor. In addition to that, not only did they wait 2 weeks, but they decided to drop the motion in the middle of depositions when the TCC and the counsel on this call are preparing and taking depositions. 2-3 a day. Tuesday alone, Your Honor, we had 3 depositions and a hearing with the court. And on Tuesday, when they requested that a fully briefed motion that they filed and for which they rushed to file a reply brief be adjourned and put off for another 2 days until today, they never once mentioned that they, hours later, were going to file another motion to dismiss. Now, presumably, they wanted that motion heard before there was a ruling on the other one, but this is the type of gamesmanship and lack of transparency, Your Honor, that should not be countenanced, and I request that on those bases alone, this motion be denied. Your Honor, with respect to the merits, with respect to unfiled claimants, the court did rule to some extent on that on Tuesday. As we noted in the brief, there were requests by the AHC for lists to know the whole pool of claimants to calculate liability. Your Honor said, I don't see how it's relevant, and it doesn't really matter if it's 50,000 or 30,000. Your Honor did question the relevance of all of this. And Your Honor did say, you know what, let's come back to this after the motion to dismiss. And that's exactly what should happen here. With respect to the idea that the relevance that they purport, that the debtor purports, is a pretext. You know, counsel says, well, we just asked 10 people, but we don't have to ask everyone. If they really wanted to figure out who the entire pool is, they would have sent discovery to all of the law firms. They didn't. And these law firms, they say, well, these 10 law firms happen to have taken a leadership role. These law firms did not sign PSAs. These law firms did not file claimant lists with the PSAs. They didn't file lists with the 2019. It's just completely apples to oranges. And even the AHC, apparently, Your Honor, has not disclosed. Its own members have not disclosed all of the claims. According to the recent testimony this week from Mr. Nakawati, he thinks that the PSA is just an agreement to agree. There are lots of issues to work out. He doesn't think or doesn't know if the agreement is good for some claimants and not for others. And he does not believe that he even filed or listed his mesothelioma claimants on his lists. This idea that we have to have the unfiled claimants listed is betrayed by their own conduct. Number 4, Your Honor, as counsel has said, so I won't go back into it deeply. And let me just add to that other point. Counsel for, I see the hand being raised by counsel for the AHC. Counsel for the AHC confirmed as much on the call Tuesday, saying, yes, a plan is on file. But as I've said at the last hearing, we don't necessarily agree with everything that's in it, and we're hard at work with the debtors to try and have an amended plan filed that we do agree with. Next, Your Honor, with respect to the privilege issue, a claim that has not been filed is privileged. The only communications about it are between a client and its counsel. It is privileged. It is off limits. There are no indicia of reliability. When somebody determines to file a claim and goes ahead and files it, the counsel is subject to Rule 11. has to do due diligence into the merits of those claims, there are indicia of reliability. The idea that you can ask an attorney who has, and to use the words of counsel for the TCC, we're not asking how many claims will be filed. We're just asking how many claimants have sought counsel. The idea that that is somehow not privileged and subject to discovery would contradict every discovery principle I'm aware of, Your Honor. I'm fairly certain that if I ask White and Case, has J&J approached you about any potential lawsuits? Have they consulted you? Whether or not you've decided to file anything is way out of bounds, Your Honor. The fact that, and this was in the briefing, that some claimants have disclosed their unfiled claimants. The AHC has filed some, apparently not all. Certain firms have responded by providing some, does not impact the privilege or decisions of anybody else. Your Honor, on the $8.9 billion being inadequate, they asked for the basis. They were told by the TCC we didn't have anything non-privileged. The law firms, to the extent that, have given them answers, they apparently just don't like the answers. Again, damages analyses are privileged. There's not much to ask about that conceivably could be not privileged or already in the public or within the knowledge of J&J. And the same, Your Honor, is true with respect to the questions about financial distress. The motion should be denied because of the gamesmanship, Your Honor, and on its merit, it fails as well. Thank you, Your Honor.
Thank you, Mr. Winograd. Mr. Branham?
Morning, Your Honor. I guess afternoon now, Eastern. I don't have a whole lot to say here except to simply join in what Mr. Satterley and Mr. Rucktershell and Mr. Winograd have already articulated. Our firm is very similar in terms of the types of cases that we take to the casing firm and the type of analysis that we do. And just because we're hired doesn't mean we've decided to file something. I will tell you that I repeatedly, at least twice and maybe 3 times in my recollection, reached out directly to counsel at Jones Day, asking them, help me understand what the authority is for you to ask for this stuff. It's privileged. What do you think is not privileged? And the answer was, see our papers. Now let's have a phone call. Not any of that. And then, we're dragged up here as a law firm. And by the way, Judge, I'm admitted pro hoc for a client in this case, but not for my law firm. So I just want to raise that because I don't want to create a problem. But the idea that this needed to be done this fast, that it was effectively done, as you heard from others, without any meaningful meet and confer, and really without any discussion at all or willingness to discuss the privilege and work product issues. I think at the end of the day, it belies what this is actually about, which is they focused on people who drive hard and maybe that they feel like are thorns in their side, as opposed to any legitimate basis for discovery. And so I would certainly, on behalf of my law firm, which is all this was directed to, and for the reasons stated by everybody else, ask that you deny the motion.
Thank you, Mr. Branham. Mr. Hanson?
Thank you, Your Honor. Chris Hanson with Paul Hastings on behalf of the ad hoc committee. Your Honor, I simply wanted to say one thing, which is in response to the gratuitous comments from Mr. Winograd about Mr. Nachawati, which really had nothing to do with this argument, but they seem to not be able to resist at any point in time. If they wanted to cite the full facts from the deposition, Mr. Nachawati's got about 5,000 claimants on file, and there were apparently 50 visas that weren't put in there. So it's not relevant to this point, but I wanted Your Honor to know that. I also wanted to point out to the court again that we're the only party who's filed the 2019. If you look around, you're hearing lawyers say, I represent multiple clients. I'm appearing in the case. I'm making arguments in the case. And notwithstanding Ms. Richendorfer's comments from last week about how she doesn't think everybody has to suddenly comply with 2019, they do. And they need to file those 2019 statements. I don't have anything else, Your Honor. I just wanted to give you that factual background.
All right. Thank you. Ms. Jones?
Good afternoon, Your Honor. Laura
Good afternoon.
Pachelsky Stang, Zeal and Jones. First, Your Honor, it's wonderful to see you feeling well. It's good.
Thank you.
Your Honor, just one quick comment. We were referenced, Arnold Lincoln was referenced earlier in the hearing. And Your Honor, just because we did have that specific reference, I want to make sure you knew I was listening and going to respond. Your Honor, after all the comments that have been made, I have nothing further to add other than what the TCC has already said, Your Honor. Thank you.
All right, thank you. Mr. Maimon.
Good afternoon, Your Honor.
Good afternoon.
It is
Good
afternoon. I'll be brief. I think that there's a disconnect here between the Jones Day lawyers and the reality of practice as it exists outside of the bankruptcy process. My colleagues have explained the process that we go through with regard to vetting claims and deciding what claims are viable and what claims can be filed, and the advice that we give our clients about that, which are clearly privileged. Mr. Ruckteschell talked about discovery on lawyers as non-parties. We are non-parties. Interrogatories and requests for production of documents are discovery vehicles for parties. We did accept the subpoena because we recognize that you can subpoena a non-party, but the subpoena asks for documents. And I would just raise with Your Honor asked the question of Mr. Ruckteschell about, well, what about just talking about the number of people who've come in your door or the number of people who've signed retainers? That number doesn't exist outside of documents. And it's not incumbent upon my firm to start doing work and tabulating things. One of the things that we do is that we investigate claims, and we also assemble documents. We have to be retained in order to be authorized to get medical records for our clients. We do get medical records for our clients. We get the pathology reports that confirm whether or not they have the disease that might be filed about. This is in sharp contrast to what a lot of the PSA partners of J&J have admitted in their depositions. We don't have any confirmatory documents or pathology reports. I have to get those. Those are privileged. If a client decides not to file a claim, it would be a HIPAA violation for me to start turning those over. The Jones Day lawyers cite no authority, none whatsoever, for discovery against lawyers as opposed to discovery against parties. And in fact, their application within their motion to not file a memo of law should not be taken by the court as the bravado that this is all simple, that they get what they get. It's a recognition, quite frankly, on their part that the law does not support them. As Mr. Satterley said, I've litigated cases with him, as well as others who are the subject of these motions for years, and our communications about various issues, our communications as representatives of members of the committee, our communications with counsel for the TCC, they're privileged, and we shouldn't have to start talking about that. Finally, with regard to the valuation of cases, the subpoena talks about, what is the average amount? There is no average amount. That's not the way the ethical rules that we have to live under require us to conduct ourselves. Each client has the authority to either accept or reject an offer made to him or her. And we cannot impose upon our clients, quote unquote, average settlement values. And we don't approach, it would be a violation of our ethical rules to approach a one size fits all categorization. You have this disease, this is what you get. That might be ultimately what happens in a bankruptcy, because it's imposed on people. It might be in other types of situations where there's an administrative type of a program where this is the amount that you get, whether it's a tax credit or vouchers or what have you. But in litigating our cases, that is against the ethical rules. Finally, with regard to the liability is not only and the damages that a defendant owes is not simply a matter of the medical bills or the lost earnings that a plaintiff has, or even, quite frankly, the pain and suffering. But the liability of a defendant is impacted also by the strength of the case against it. And so, yes, for sure, I have a lot of liability documents that J&J has produced to me, but they produced them to me and they know them, and it would fill up Your Honor's courtroom more than it's already filled with boxes to have the liability evidence against J&J. But I also have my analyses of that in documents. My analyses are privileged. They're work product. I have the analyses that Mr. Satterley and I have worked together. Those are privileged. Ms. Odell, Ms. Parfit, in dealing with various issues, we exchange, as co-counsel in cases, thoughts and mental processes. These are all privileged. And the fact that you have absolutely no legal authority put forward by the debtor that supports this motion, and I'll set aside the knee-jerk reaction that seems to be to just get a short order, a short time frame motion so that everybody has to come within 2 days, and maybe one can be pulled over over the court's eyes. The lack of any authority either for the discovery against lawyers or for the evisceration of the privilege dooms the motion. I thank the court for its time.
All right, thank you, Mr. Mayman. Be careful. You don't want to handcuff Mr. Winograd. We may be having motions on shortened time from him shortly, so from what we've been told. Ms. Placona?
Thank you, Your Honor. Just some few comments. Speaking on behalf of the Barnes Law Group, we echo the comments made by Mr. Ruckdeschel claiming privilege and work product. And the Barnes Law Group has reviewed hundreds of cases and decided not to take those. So we repeat those arguments. I also filed an objection last night on behalf of the firm Arscraft and Jarrell, so at docket 661, that I just asked that Your Honor take into consideration that adopted the objections by the TCC. Thank you.
Thank you, Ms. Placona. Mr. Torborg, we're back to you.
Thank you, Your Honor. All right. I'm not going to try to rebut everything that we heard over the last, probably going on an hour. I do want to hit a couple of things. Start with some procedural things and then some substance. First, in terms of the timing of the motion, I mean, Mr. Winograd wasn't involved in all these communications that went back and forth between us and the law firms. Deficiency letters were sent. We sent our last proposed compromise email on the Thursday before Memorial Day, right? If we had filed a motion immediately after sending that, we would have been, and we offered to meet, and we invited law firms to meet and confer with us. They didn't. Okay. If we had filed the motion the next day or over the weekend or even Monday, we would have been accused of jumping the gun, right? So we're really trying to be fair to everyone and trying not to burden the court. We have substantially, limited our requests here. We heard some argument about requests we didn't even move to compel upon. And then also the other procedural issue is the authority question about whether we can serve Rule 33 and Rule 34 discovery on a law firm. Well, we took that off the table by serving the document subpoenas. So I don't know why we're hearing so much about that. Substantively, we have three issues. One is the relevance of unfiled claims and whether they're privileged. I haven't heard any legal basis to say that the number of unfiled claims a law firm may have is privileged. And I don't think there is any. And if it was, I would be very surprised that two of the 9 plaintiff firms actually gave that to us. It is relevant. And as Your Honor recognized, at best, it goes to weight, right? Or at worst, it goes to the weight of the evidence. How many unfiled claims have been accruing? Remember, claims haven't been filed for 18 months because of the bankruptcy, right? So the inventory of claims that's built up is relevant to financial distress. The fact that there might be some claims that eventually aren't filed, okay, that doesn't make the number of unfiled claims not relevant. In terms of the request number 2, communications relating to the proposed settlement, yeah, we recognize there might be some communications that are privileged, right? But there might be communications that are not. It's clearly relevant. I haven't heard anyone say that's not relevant. So we want the law firms to actually search their files for communications with other law firms for which they do not share a common interest and produce those. So those are the follow-up things I wanted to make. Thank you.
All right. Thank you. Mr. Winograd. You're on mute.
Sorry, Your Honor. Just a few points to address what counsel said. Number one, with respect to Mr. Nakawati, Mr. Nakawati plainly testified that he had a number of unfiled claims. He gave that number. It was approximately whatever it was. And he then said that he does not believe that any of the meso claims were filed with the 2019. That was the point that I made. It is, in fact, accurate. Number two, Your Honor, with respect to timing, we are all on a breakneck pace. We all understand that. And motions will have to be filed on shortened notice, absolutely. But to wait 2 weeks to file one and then drop it, a motion like this, in the middle of depositions is a bridge too far, Your Honor. The idea that the claims have to be relevant, they are not claims. As counsel itself described them, we're talking about consultations by a victim with an attorney. That is not yet a claim that has any indicia of reliability, and anything that has been transpired between that client and the attorney is privileged. It's simply all off limits. And I just don't, the counsel really hasn't addressed that. I don't know that he rebutted the other points that we've made, and for all the reasons that we said earlier, Your Honor, I think this motion should be denied summarily. Thank you, Your Honor.
All right. Thank you, Mr. Winograd. Mr. Ruckdeschel, you had a further comment briefly?
Yes, Your Honor, very briefly. There was a comment just a minute ago from my colleague at Jones Day that nobody's disputing that this information is relevant with respect to the documents they're demanding from plaintiff law firms directly. And that's exactly what we've disputed. It strikes me as the comment in the hearing with Mr. Placitella a minute ago, where the claim was made that, nobody's disputing that the stay applies. And Mr. Placitella has to get up and say, that's exactly what we're disputing. The stay doesn't apply. We have disputed at every step of the way any relevance of this information coming from the law firms. There was no argument as to whether it was relevant. And I pointed that out in the opposition to the motion. They cited 2 cases in the motion with respect to the 2 requests for production at issue with my firm. Those cases stand for the proposition, if you take their parentheticals correctly, that relevant evidence is discoverable. Duh. But this evidence isn't relevant. And to then come in and say, well, I don't have a case for you that it's relevant and I can just ask the law firm for whatever they've got beyond what was their clients. And no one's disputing that. It ignores the truth. It ignores the papers that have been filed. It ignores the responses. It ignores the entire meet and confer process and the responses with respect to that. And it's just not proper. You got to end this, Judge. Thank you.
Your Honor, Lee O'Dell from Beasley Allen.
Yes.
I have my hand up and somehow it's fading in the background. If I could have a moment.
That's quite all right.
Thank you. First, I would just join in the comments and arguments been made by TCC counsel and others, particularly in relation to estimates of either Beasley Allen's inventory or group of cases or to the aggregate liability. Clearly, those impressions, analyses, evaluation of the facts are work product and are privileged and should not be produced. But I wanted to raise my hand and add that there have been comments made by Mr. Torberg that the plaintiff's law firms have not participated in this process in good faith, have not looked for documents that might be responsive, they're non-privileged. And that's just not the case. In relation to communication with other lawyers, communication with co-counsel has been well described, are privileged. But in the case of communications with other lawyers that are non-privileged, I can say from our firm's perspective, even though we're not a party, even though we have not filed a motion to dismiss as a firm, we took steps to make a good faith review, and where there was a communication that was not privileged, we produced it. So to suggest somehow that there's been an improper approach to this by plaintiff's counsel, I think is not accurate, and I just wanted to let the court know that.
All right, thank you. Ms. Parfit?
Thank you, Your Honor. And again, I'm glad to hear that you're feeling better. Your Honor,
thank you.
Points that have perhaps not been raised and discussed by others, but as Ms. O'Dell indicated as well, we have taken any and all requests by counsel quite seriously. That's how we handle all types of requests. We made a search of our files, despite the fact that we felt any of the requests the defendants asked that we had objected to had some type of relevance. We did not. I'm right down the road from Jones Day, and I would have been delighted to receive a request to meet with them and talk with them. I suspect it would have been a very short meeting, but to suggest that there was an offer, there was not. Also, with regard to investigation of our claims, and perhaps very relevant to what we will see down the road, what our firm does, like all other firms, most of the firms on this recording today, is do an investigation of their claims so that, in this particular case, as it pertains to ovarian cancer cases, what we do file are epithelial ovarian cancer cases that are supported by the science and supported by the Daubert ruling of the Honorable Judge Wolfson. So that does take time. And just because someone retains the law firm of Ashcraft and Jarrell does not mean we ultimately make an assessment that their case is one that need be filed. And so those discussions, those investigations are all highly confidential and privileged until such time as a case is filed. And then at the time the case is filed, that's public and available to LTL and any other defendant in this case. As to the other requests with regard to the 8.9 and any comments, I agree with Mr. Ruckershelf and others. I'm sure we all are quite opinionated on 8.9, and when given the opportunity, would love to share those opinions with regard to that type of evaluation of these serious claims, and a number that would be so minimal in its ability to compensate these claims. But that said, any and all those types of communications are indeed privilege and are indeed work product, as are the financial distress analysis that we or any other clients would make. But I just wanted to, I felt compelled to say, as we've heard quite a bit, the firms that have spoken, the TCC, whose opposition we do in fact embrace, I think have been very clear with regard to the type of investigation they make and the seriousness with which we respond to any requests, not only of the court, but frankly of counsel. This matter involves women that are dying, women that have died, and to suggest we would do anything less than that is an insult. Thank you, Your Honor.
Thank you. Mr. Bolton.
Yes, Your Honor. I didn't expect to speak, but I got a call from Ms. Lisa Bush of the Whites Luxembourg firm, who unfortunately, for whatever reason, is not appearing. She had her hand up, but apparently she's not within the webinar. So she just asked me, lest Your Honor, as you review the documents, to relay to you that they did file a response last night in opposition, and she stands on it for the Whites Luxembourg firm, as well as the statements made by other colleagues, as well as by the TCC, and refers you to the fact therein that as well they were not properly served. So that's all I have to do, Judge. I'm just transmitting that from the Whites Lux firm, who through whatever miscommunication was not on the webinar. Thank you, Your Honor.
No problem. I did receive their submission, and I hope your daughter's program grammar event went well.
Your
All right,
Honor, thank you so much. Thanks so much for the courtesy of extending this.
No problem. Mr. Torborg, last comments.
Thank you. I'll be very quick. I just want to point out, again, we're talking about, on the first issue, we're talking about individuals that the firm has accepted as clients. Not every single person that's walked in their door and discussed the potential filing of a claim. So there has been some filter between is any old person and someone who might actually file a claim. So we think that information is highly relevant and should be produced. Thank you.
All right. Bear with me 1 second. All right. So there are countervailing issues with respect to any Rule 26B1 context. First, the requested discovery has to be relevant. And as we all know, in 2015, relevancy was changed to incorporate concepts of proportionality. And relevancy now is defined as any matter that bears on or that reasonably could lead to other matters that could bear on any party's claim or defense. That's very broad. However, the restrictions on proportionality then weigh in. So this court has to take into account the importance of the discovery in resolving the issues and whether the burden or expense involved in the proposed discovery would outweigh any benefit. In looking at the document demands issued in conjunction with the subpoenas, the court is of the view that the bulk seek privileged information, the range of settlement demands or offers that have been extended, communications with respect to the propriety of the $8.9 billion settlement, the vast bulk of any such communications or documents exchanged between plaintiffs' firms would, to this court, be in all likelihood, without looking at a specific communication, would all likelihood be subject to a privilege. Now, I believe Mr. Torborg is correct. The court could endeavor to say, okay, this, provide such discovery, identify the privileged communications in a log. That goes to proportionality and the expense and the time that would be associated in doing so as compared to the slim number of results that would produce a non-privileged document. So the court is not going to direct that. The court also takes into account the arguments made with respect to clients that come into the door, through the door. They may sign retainer agreements, but their claims are under review and investigation. And there is, of course, a percentage that do not lead to actual lawsuits being filed. At what point the determination is made between investigation and the decision and determination to bring a suit is a fine line. Mr. Satterley identified various situations or potential clients where the determination has been made to bring suit, but suit has not been brought. Obviously, the investigation has moved beyond a point in those situations where Mr. Satterley can comfortably identify claims that would be. If we had a claims bar date, most of this would be academic. All creditors would be put to task to file claims, and we would be able to see it. Maybe at some point we get to that. At this juncture, I am going to direct compliance with the subpoenas in a limited fashion. The law firms are to produce documents which evidence, refer, or relate to a number. That number being the number of filed claims, or and by claims, let me use my language. These would be claims for injuries due to use or exposure to talcum powder that has been sold or marketed or distributed by J&J or any of its affiliates. The law firms are to produce a number of claims that they are handling which have not been filed, but for which a determination has been made to bring suit. So two numbers: those that have been filed, which I'm not sure Johnson & Johnson or the debtor requires, but if they do, there's no privilege, and the number of claims for which there has been a determination to bring suit but have not yet done so. Now, I'm not looking for individual names or information on those cases. I do not see a privilege issue. We're speaking about a number, and that's it. Beyond that, the motion is denied. Any issues or clarification? Mr. Ruckdeschel?
Your Honor, I just want to make sure that based on the motion, the discovery request that Your Honor's ruling relates to is interrogatory number 1, and that was the one that required or requested a number of filed or unfiled claims. And Your Honor has ruled that to the extent that there wasn't an answer to interrogatory number 1, you're ordering compliance as just described of an additional answer, and only for that discovery request, correct?
It would appear so. Mr. Torborg, you want to weigh in?
Yeah, I mean, we also had a document request in the subpoena that's pertinent to this as well.
The document was, again, the request was for documents which evidence the number.
Yeah, sufficient to show.
Again, certainly the document is not to include any privileged information or personal privacy information. It's simply a number.
So my concern there, Your Honor, again, Jonathan Ruckdeschel, my concern there is what essentially is being requested at the 2 document production requests that were addressed in the motion to compel did not relate to the document requests about number of claims. The discovery request relating to the number of claims that was a subject of the motion to compel is interrogatory number 1 and interrogatory number 1 only. And so I think that the court's ruling has to be limited to what was at issue in the motion, and the only one that was at issue in the motion with respect to number of claims was interrogatory number 1. And so I think everybody understands what Your Honor has said about the information that's required to be provided. But because the only thing before the court in that regard was that one discovery request, I think that the court's ruling has to be confined to that on due process grounds, if nothing else.
Well, but maybe there's a clarification. My understanding was that there was a document request associated with the interrogatories.
Not an issue in the motion to compel.
Mr. Torborg?
We have a document request for documents sufficient to show the total number of talc claims. Yes.
If I may, Your Honor.
Mr. Maimon?
Yes, Your Honor. This is an impossibility. It's something that might exist in Jones Day where they keep documents of numbers of cases. But we have retainers from clients. We have clients' personal information. We don't have a document which has a number on it of unfiled cases or quite frankly, filed cases. We have.
Then your response is we don't have any document that meets that discovery request.
Well, I do have the retainer agreements. I do have the client medical records. I don't want to be in violation of Your Honor's order. So that's why I think Mr.
I thought I've made it clear. I don't expect you to deliver retainer agreements with names or the medical record. If you could use those to answer the interrogatory, then that, as far as the number.
So I think that, and that's why I think that Mr. Ruckteschell point is really well taken, that the interrogatory asked for the information that Your Honor has ordered us to give, which is give us the number of filed cases, give us the number of unfiled cases, as Your Honor has defined those. But if Your Honor now accedes to Mr. Torberg's request that, oh, well, we want documents, that opens up a Pandora's box, and we're never going to get anything done here.
All right. Mr. Torborg? And then
I just wanted to say, I mean, our motion definitely includes request for production number 1, which is documents sufficient to show the number of filed and unfiled claims. Paragraph 8 of our motion.
Mr. Satterley?
Yes, Your Honor. I accept Your Honor's ruling with regards to identifying the number. We can do that. But if Your Honor extends that to documents, first of all, the request is so vague and unduly burdensome, and it would literally take me weeks, if not months, to have my staff go through all my files to try to find documents responsive to this. I'm in trial right now for a dying mesothelioma. I'm also trying to assist with regards to the preparation of the motion to dismiss hearing, which Your Honor set. This is really harassing.
I'm going to make it easy, Mr. Satterley. I'm going to make it easy. At least I think I'm going to make it easier for all of you. The only document that has to be produced would be an actual list, if it's maintained, of claims filed and claims to be filed. Otherwise, I'm going to ask you for the interrogatory response. I'm not looking to amass any piece of paper that would show a claim.
Thank you, Your Honor.
All right. I think we're done for the day. We should be able to figure this out. Thank you all.
Weekend.
Thank you. Take care, everyone.
Bye now.
Record.